fortunate to have Jodi Mathieu. She is a certified IRB analyst at the ORP. Jodi has been at the ORP for the past 19 years. And her current responsibilities include she's the primary contact for principal investigators whose last names begin with L through N. She manages day-to-day activities of the IRB program and supervises a team of IRB analysts. She coordinates committee reviews of new study applications and modifications and reviews for human subjects and research, and she serves as a designated reviewer on the non-committee of new study applications. And she is also a member of the IRB. And today, her presentation is entitled IRB 201, New IRB Requirements for 2018, Revised Common Rule. Thank you again for being here.
So how many of you have done human subject research? Oh, good, we have some. Sometimes we have none. How many of you are principal investigators on the study? How many of you are mine? L through N. Your last name being L through N. Are you PI on the study? Yep. Okay. Just checking. So, as Deb said, what we're going to talk about today is there are lots of changes happening in human subject research world. I'm not sure if my brain, well, it has to be trained in order to learn all this new stuff, but 19 years using one set of regulations, and now they've changed everything on me. So I have to retrain the brain. So what we're going to talk about today is the revised common rule. And so that is 45 CFR 46. That is the common rule that is the federal regulation in the protection of human subjects in research. So there's going to be some fun things. It's not working. Did I break it?
Yeah. Did you break it? Probably.
Yeah. Oh, okay. All right. So a couple of things we're going to talk about today are important dates that we were given, what we know, what we don't know with these regulations, some key changes that are happening to the common rule, so what's changing for exempt level review studies, changes to informed consent requirements, changes to requirements for continuing review at the expedited level, and cooperative research. One of the regulations they're putting in for cooperative research. We'll talk about how we're transitioning, and we'll give you some recommendations on if you're going to be submitting during this time period. And then we're also going to discuss some of our other changes that have been happening for NIH-funded studies. So they're changing things every which way they can at the federal level just to keep us all on our toes. So some important dates. So the final rule for the changes to the common rule was published on January 17th, 2017. These changes were actually given to us in the last days of President Obama's administration, but President Trump's administration put a 60-day freeze on it before they released it to everybody saying these were the changes. So the changes were released. The effective date was supposed to be January 19th of 2018. But on January 17th of 2018 at like 4:52 in the afternoon, we got an email from the federal regulators saying the common rule implementation has been delayed 6 months. So we pushed everything back we were doing until July 19th of 2018. So basically, all of the changes that they have proposed in this regulation, with the exception of the requirement for a single IRB review for cooperative research, and we'll talk about what cooperative research is in a little bit, goes into effect on July 19th, 2018. The cooperative research requirement, the single IRB requirement for that, does not go into effect until January 20th of 2020. Y'all got those dates down because there'll be a quiz afterwards. We're still trying to keep them all straight too. Does anybody have any questions about all these good fun dates and things like that? It will matter to you if you have a current IRB and then submit a new one after the regulations go into effect. Okay, so those are the kinds of things that we have to keep track of and figure out how to keep track of. So as I had mentioned before about the common rule, it's our set of regulations that must be applied to human subject research that is federally funded. We apply that regulation generally across the board to all human subject research. We do, regardless of funding, because whether or not you get funding, your subject should be treated the same and have those protections. With exempt research, we have, because it is exempt from IRB review for right now, until July 19th, we do exercise flexibility in the regulations. There are some studies that are not federally funded that we review at the exempt level, that if you were federally funded would have to be reviewed at the expedited level. So we do use some flexibility in there with non-federally funded research. With the common rule, it is administered by the Office for Human Research Protections and the Department of Health and Human Services. So DHHS is responsible for this regulation, but along with them and 15 other federal agencies have signed on to these changes. So not all of the departments at the federal level have signed on. So that's going to be another fun thing for us to kind of keep track of. These are the two that did not sign on. So the things that we're going to talk about today, if your study is FDA regulated or is funded by the Department of Justice, the new regulations don't apply. We have to use the old regulations. So we'll have to pick, yes?
I just have two quick questions. What is IRB stand for?
IRB stands for Institutional Review Board. And so within the common rule regulations, you are required to have a committee established made up of no less than 5 individuals who review studies that involve human subjects in research.
Right.
So there are different levels of review. There's an exempt level, and basically what happens there is the government gives us 6 categories. So if your research fits into one or more of those, we can review it at the exempt level. That's where we can exercise some flexibility. Penn State created their own for non-federally funded studies, kind of help move some things that don't involve risk into that exempt level. It doesn't fit into exempt, it goes to the expedited level. There they've given us 9 categories, and so your study has to fit into one or more of those categories and be no more than minimal risk. If it's not that, then it goes to the full committee review. And so our committees meet once a month and they review those studies. But also sometimes if you have prisoners in your research, that automatically gets reviewed by a full committee. And there are some things that the other categories exclude. So in your everyday life, you could go to the doctor and they say, I want you to get an x-ray. We can't review x-rays anywhere but at the full review level because of the radiation being administered. The regulations exclude that and it has to be full review. So while that's something you might do every day, we have to review it by the full committee.
Okay. Which is like the top.
The top tier. And before we even get to those 3 levels of review, we actually have to figure out if what you're doing is human subject research. So when you look at the definitions, the information about a human subject, the definition is information that's being collected by a living individual through an intervention or interaction, or you're obtaining private identifiable information. So if you're interviewing a CEO of a company and you're asking them about company policies, does your company have a policy on this? How many employees do you have? You know, has your company been sued for sexual harassment? The information being gathered is about the company, not about a living individual. So that wouldn't even be a human subject. But if you ask them all those questions and then you say, what's your opinion on your company's policies? And how old are you? You know, what's your ethnicity? What's your background? Where'd you get your degree? Then you start asking things specific to the person, so that moves it into human subject. Yes?
This one's getting a little ahead, maybe, but for that common law, would something like Madam review the study, but didn't Stanford kind of have like a
The
prison thing?
Mm-hmm.
Like, would that fit in these kind of regulations? Like, how stingy are they?
So that was actually That was a good study of what not to do.
Oh, okay.
So that study had deception in it. That doesn't mean that research can't have deception involved in it. But the way that the subjects were done, the history of that study, so they had the psychology students, they posted the advertisement in the paper and said, you can get paid like $2.50 for whatever, to participate in this study. And so what they did was whoever signed up, they randomized them, some were the prison guards, some were the prisoners. The ones that were prisoners were actually arrested by the police coming to their house and taking them to the makeshift prison in the basement of the psychology department. So the whole purpose of their study was about what happens to good people when they're in a position of power. And so what they noticed after, I even forget how many days, I think it was supposed to be a 2-week study, and they stopped it after like 6 days, I believe. And it was this graduate student, maybe later married, that convinced him to stop the research study because the guards had you guys are all too young to remember Chips, right? Anybody remember the TV show Chips? Yeah, you're all too young. They had those reflective sunglasses that are coming back in where you can't see their eyes, so it makes them impersonable. And the prisoners had the numbers and stuff. So they didn't refer to them as people, they referred to them by their numbers. And so some of the guards started getting abusive, not physically, but mentally abusive. One of the kids wanted to quit, but didn't feel that he could quit, went on a hunger strike. And so there was a lot of stuff that happened in that study. And so when there were things that were happening in Iraq at Abu Ghraib, they started talking about how Dr. Zimbardo's study said this was going to happen. Because that's exactly what happened here. Because you had the U.S. military that was involved in the pictures with the naked pyramid pictures of the prisoners in Iraq and things like that they were doing to them. And the soldiers said, look, I was only doing what I was told to do by my commanding officer, so I really can't be held accountable for this. And so again, if you would see these people as, we see them as good people, so what happens to good people when you put them in a position of power? And when all that started happening, Dr. Zimbardo, started talking again about his study. He was like, this is exactly what my study proved. And so we need to be mindful of these kinds of things. So while the research design was bad, the information that you got out of his study was really good, just like the Milgram study.
But today, if I were to bring that study to you saying, this is what I want to do, would the regulations let me?
It depends, and it would depend on your study design.
Okay.
What your stopping parameters are. I mean, we've had kids that wanted to replicate Milgram as he did it, and you can't do that because you have to tell people that there's deception involved. And so that didn't happen with Milgram. And some of the subjects, if you ever go, Zimbardo has a website on the Stanford Prison Study. And so they do interviews with the kids that were officers who say, I can't believe I acted like that. That's not who I am. We have kids that were prisoners that they interviewed and they talked about and they said, I didn't feel that I could quit. They told me I could quit, but I didn't feel like I could quit. And so that is another thing with human subject research. Participation is voluntary. You can stop at any time. You can choose not to answer questions you don't want to. And there is no penalty to you quitting. It's just, I'm done, I'm out. And so that's important for researchers to make sure that it's not coercive or you're influencing them. So that's one of the reasons IRBs look at compensation. Because we don't want, if you're looking at a lower socioeconomic population and you want to pay them $100 for doing a 15-minute survey, that's not going to happen. Because you've now enticed them by the money. The only reason they're participating is for the money rather than their willingness to just participate in the study. They would otherwise say no, but I'm going to say yes because you're giving me $100. Okay? So with this, with the application of changes, so if anybody does drug or device research and you submit to us after July 19th, your study is going to have to follow the old common rule regulations, so the one that we have right now, not the new ones, because they have not signed on and agreed to these changes. So there's only 2 of them. So the exemption categories. So like I had said, the government gives us 6 categories. We have a 7th category that we'll talk about here in a minute. So in the past, when we look at exemption research, the IRB is not the committee that reviews exempt research. The regulations say that it's exempt from IRB review, but here at Penn State and most major research institutions, those determinations and the regulations indicate the researcher can't make that determination that your study is exempt because you have a conflict of interest. So what that means is that somebody who's qualified has to make that decision whether or not your study is exempt. And for us here at Penn State, it is myself and the other 5 IRB analysts in our office. So, yeah, I said that. Under this new rule, everything is the same, except there are certain categories that the regulations have now said that they've made changes to that would require a limited IRB review. And so what that means is we would be looking at whether or not the protections you have in place for subject privacy and data confidentiality are good enough for that study. So if you're asking questions about like what your favorite ice cream is, even if you get identifiers and you say, look, I want to store that here, generally that's going to be okay because there's nothing there that is sensitive for your subjects that would harm them if that information got out about what their favorite ice cream flavor is. But if you're having parents complete a survey and asking them about corporal punishment in their home, and the questions specifically are addressing whether or not they spank their kids or, you know, their drug and alcohol behavior and stuff like that, if their name was associated with that data and it got out, if it could put them at risk of certain things, what we do then is we have to look at limited IRB review. And so me as an IRB member, I'm looking at it 2 ways. Probably have a split personality as an IRB analyst and an IRB member for this study. But I look at it as an IRB analyst and say this is exempt. As an IRB member, I have to look at it and make the determination of one thing, and that's that your privacy and confidentiality provisions are adequate for the questions that you're asking. So they call that limited IRB review. Why didn't they just make up another category? I don't know, because it's going to be all kinds of fun. So what we have, so for exempt category 1, does anybody know what exempt category 1 talks about? So exempt category 1 talks about education research. So when you're doing research on normal educational practices occurring in a normal educational setting, you could be looking at classroom management techniques, the development of curriculum, and things like that. One phrase they added to this exempt category was about whether or not, one of the things we have to take into account is whether or not this research has an adverse effect on the learning of required educational content for the student or on assessment of teachers. So if I am a researcher and I want to go into the school and I want to pull a child out of social studies class to administer a survey, that may not be able to happen now at the exempt level because I could be having an adverse effect on the learning of the educational content of that student because they're missing that class. So those are new things that we have to take into account. Not that we didn't take that into account before, but we have to make sure that we're mindful of it and there would be an explanation or justification for that to happen. So exempt category 2. Exempt category 2 previously, well, currently right now, what it talked about was the use of educational tests, interviews, questionnaires, or the observation of public behavior, where the researcher was not, observation of public behavior. The category could only include children if it was under the guise of administering educational tests, or if the observation of public behavior of the children occurred when the researcher was not interfering or intervening in that observation. So they weren't setting things up a certain way to see how somebody reacted. And to be clear, this category does not include interventions. So if you were asking them to do a task such as think of a time when your boyfriend cheated on you, and these are risk studies that come off the top of my head, so I'm not making some of this stuff up. You know, and write as detailed as you can how you felt about that. That's not a survey, that's not a questionnaire, that's not an interview. So it wouldn't fit under exempt category 2. That's why we created this exempt category 7, because that would fit there. It also does not include the collection of biospecimens. It does not include linking their survey responses, for example, to other available existing protected or private identifiable information. We talked about children as participants in that category. So now, basically what this said before was you could do surveys and questionnaires at the exempt level as long as you were recording the information without identifiers, or if the information had identifiers and it was released, that it would not put subjects at a risk of harm to civil or criminal liability, employability, insurability, financial standing, or reputation. So they've changed all that now and said, you can collect sensitive identifiable information and it can still be exempt, but we have to do this limited IRB review again. So for this category, if you are collecting sensitive identifiable information at the exempt level, we have to do that limited IRB review to make sure that your confidentiality and privacy provisions are adequate. Anybody have any questions about that? Yes, ma'am.
So how would a limited IRB review take? Because some of us have like comprehensive exams that specifically deal with data collection, and if we're on a very strict timeline, I just wonder like how far in advance we should plan to collect all of the data or to submit everything into IRB on time so that we collect data by the time we do our comprehensive.
So our timelines, I don't know if this is going to sound weird. What I would do is as soon as you can submit the study, is I would submit the study. If you need it for your comprehensive exams, we don't require that you have approval before your comprehensive. And I just had this question asked of me the other day. Do you, it was about defending in front of your committee. They shouldn't be submitting, right? Do you allow that? And I said, we don't have anything to do with the graduate school. When you submit is when we review. So if your department says, we don't want you submitting until after you've defended your thesis and we've figured out what you're doing and then submit it. Or we have people who submit it, and then once they defend, if they have changes to make, they submit a modification. So whenever you submit it is when we review it. Typically for exemptions, I think it's like 10 or 12 days. Expedited, I think, are around 15. It has to go full committee. It can be a month because we have to wait for the next meeting to come around. So it depends on when you submit it. So it kind of depends on that. The other thing that it depends on is if we request clarifications, how quickly you get back to us as well. So anybody have any other questions? Yes, ma'am.
So as long as you have no identifiable information, no names, no numbers,
Yes. So if you had a study that asked it all those sensitive questions and you didn't collect any identifiable information, we can do it at the exempt level because it's being recorded without identifiers. So we can do it at the exempt level. If you were asking those sensitive questions and now had an email address associated with it, we still might be able to do it at the exempt level as long as your privacy and confidentiality provisions are adequate. And that's why with our protocol, we don't have a separate protocol for exempt research versus expedited research because we would just come back to you and say, hey, it's expedited. We need more information here, instead of saying, now you need to fill out a whole new application. Anybody have any other questions? So exempt category 3. Anybody here in psychology? All right, none of you. So the government has added a new exempt category for benign behavioral interventions. And so this was kind of what our category, our Penn State specific category was a little bit about. So they have to be, so a benign behavioral intervention has to be brief in duration, not physically invasive, harmless, painless, not offensive or embarrassing, and not likely to have a lasting adverse impact on subjects. We don't really know how to go with that. We're still waiting on guidance from them. Like when they say not offensive or embarrassing, to who? We get to your subject, but then they talk about a reasonable person. What's a reasonable person? I think I'm a reasonable person. You may not think I'm a reasonable person. So it's kind of that vagueness that we're waiting on clarification from the office that we work with, OHRP, to kind of give us. The one thing that this does allow is you can use deception in this study, where previously anything that had deception, even in our Penn State specific category, always went to expedited. In order to use deception at the exempt level, you must obtain prospective agreement from the subject. So I have some psychology researchers that don't want to tell anybody that their study involves deception. They tell them afterwards when they debrief them. That could not be exempt. If you're telling somebody up front, hey, I'm not telling you the true purpose of the study, and they still agree to participate, you can do it at the exempt level. The category, and it says the information must be collected via verbal or written communication to include data entry by the participant and or observation. Again, we're still waiting on a little bit of clarification on that one. So, because some of the things that we do are at the exempt level in our category are like think aloud tasks. So you come into the lab and we say, okay, we want you to get online and search for hotels, and you can't use hotels.com. And while you're doing it, we want you to talk out loud about your thought process of how you're conducting this search. We're thinking that would fit in here because it's short in duration, it's not physically invasive, it wouldn't be harmless or painless. We don't think it would be offensive or embarrassing, and it's not likely to have an adverse impact on us. So we think that we could do that one there, but we're kind of waiting for a little bit more guidance on this. This category cannot include research involving anything with physical sensors. So Fitbit, heart rate, EEGs, EKGs, none of that stuff. Our Penn State specific category, and I think we're going to keep it, allows for things like Fitbits. And so we would still be able to keep non-federally funded things at the exempt level. Yes, ma'am.
Does this have to be at the individual intervention?
Wait, what do you mean?
Or could it be like a relationship intervention?
It depends on the type of relationship intervention. So if you were saying, and so I've had researchers who have brought couples in and said, think about a time when your partner really irritated you, and let's have a conversation about that. That probably would not fit here, because now we're talking about not having an adverse lasting impact. So how can you say that when they leave there, they're not going to have a bigger argument because of that? The only thing that it says is it's not having, well, it doesn't say positive or negative. It says have an adverse. So adverse to me kind of means negative. But I would say submit, because we don't ask you to choose the category. So I would submit what you're doing, and then once we have the full picture, we can make that decision or have a discussion with you about it as to why we think it's one or the other. But it depends. It's my favorite phrase in the English language. That's the nice thing about having the one protocol, is that everything is in there already. So, as I mentioned, for studies involving deception, they have to be informed that they will be unaware or misled about the nature or purpose of the research, and they have to agree. And typically, at the end of the study, you're going to be debriefing them. So we have the same requirement as Exempt 2 for limited IRB review if you're collecting sensitive identifiable data. So this could include video recordings, even sensitive identifiable data. Exempt category 4, So the old category used to talk about data that was existing at the time of the submission that was either did not contain identifiable information or the investigator recorded the information without identifiers. So if you were going into, I don't know, an insurance agency and looking at, I don't know, let's talk about snow, shall we? The number of accidents on any given day for each hour when the snow fell or whatever. And you're going in and you're recording information about those accidents. You're accessing information that is identifiable, but for your research, you're recording it without identifiers. That would fit under exempt category 4 currently. This category has had extensive revisions. You can now use identifiable data in here that is publicly available. Is that right? No. For when consent is not required. So it could be prospective information that you're collecting, so it doesn't already have to be on the shelf when you're doing it. And consent may not be required. What you have to keep in mind, though, is when you're doing this, is this isn't an out to prevent you from getting consent. So if you submit a study to us and say, okay, well, we're going to be teaching this class, and so at the end of the semester, we would like to use their data for this. You still have to get consent from them because you know that it's a research study, you know the data that you want to get. And not only that, the Family Educational Rights and Privacy Act, which is not the common rule, requires you to get signed consent if you are obtaining identifiable information from an educational record. So in order to be exempt category 4, it has to meet one of the following. I was right. The identifiable data has to be publicly available. The information is recorded in such a manner that subjects cannot be identified, you're not going to try and re-identify them, and you're not going to contact them. So keep in mind, those two things just contradict what it said. Identifiable stuff has to be publicly available, and then the next one says you're recording it in such a manner that you can't identify them. Only one of these things has to be true for your study to meet that exempt category. If the research involves only information collected and analyzed involving the investigator's use of identifiable health information, then it would be regulated under HIPAA. So as the privacy board for research, our office would have to grant you the waiver of authorization. So you're getting identifiable protected health information. HIPAA requires that you get a signed authorization unless your privacy board has indicated that they have granted you a waiver of authorization. The research is conducted by or on behalf of a federal department or agency using government-generated or government-collected information that they collect for non-research purposes. Census data is not necessarily identifiable depending on what level you get access to. If you were getting restricted access from the Census Bureau, that was, they had collected, they collect it for non-research activities, and you were doing it on their behalf, it might fit into this category. Anybody have any questions about that? That doesn't mean that if your study is NIH funded, that the data is automatically conducted by or on behalf of, doesn't mean that you apply for funding and you get it. That's not what that means. Yes, sir.
And where does data from online digital sources like Twitter, where people use and leak online traces fit into?
Well, it depends. So the expectation with Twitter and Facebook and anything that's online is that you are adhering to their terms of service and conditions. So if you go into Twitter or even anything online that you have to sign up for and you're going in and you want to download all this stuff, you may need to get permission from Twitter to do that. You may, because Twitter owns that information. You may download it with, we have had people argue that, you know, some of the I don't have Twitter. I think I'm too old to understand how to use Twitter or how it works. But if I had one and it said @Jodi Mathieu, that's identifiable. But we've had people also say, well, but anybody can pick any handle they want. Sometimes they're not identifiable and it's not this or it's not their property. So there's, depending on what you're downloading, it's difficult. If you were just downloading the content of the tweet, probably not even a human subject.
without the,
Without-
collecting the handle.
Right. So, because again, when you're collecting, and this is where the definition of human subject gets tricky because sometimes the federal government contradicts themselves. The definition of human subject, when you're only using data, it talks about that the information that you're collecting is private and individually identifiable. So if the data you're getting is not private, but it's individually identifiable, it's not a human subject, it has to be both. It could be private, but if it's not individually identifiable, it's not a human subject. So those are the two things that you have to keep in mind when we're looking at data. Informed consent. So at the exempt level, we do not review recruitment materials or consent forms at the exempt level. Within the protocol, you have to explain to us how you are recruiting people and how you are consenting them at the exempt level. If you upload in the informed consent form at the exempt level, I'm not going to lie, look at it, because I just try to make sure that you're being consistent with what you're telling us in the protocol. So some of the new requirements that they have here, one of the big things that they've changed is that consent forms now must include a concise and focused presentation at the beginning of the document that includes those four things: that participation is voluntary, a summary of the research procedures, what the risks are, and what the benefits are. Now, for a lot of people that do social science research, this probably isn't going to apply to you. We're probably going to change our templates around so that we have the section about the study being voluntary and they can skip any questions if they want. We'll probably move it up closer to the beginning of the document than where it is now. But we already have the summary of what subjects will be asked to do towards the top of the document. So we might need to move the risks and benefits section up. For those of you, because, so what we're looking at, we may need, like it says here, social, behavioral, and education consent forms probably already meet this requirement if the information is concise and focused. We have some biomedical research that's 14 pages long. And so your risks and benefits may be down on page 8. And by the time you get there, people aren't reading it. And so what they're saying is at the beginning of the document, you're going to have this concise information that explains it, and then more detailed information is provided in the sections below. Does anybody have any questions about that? So additional requirements. Right now, none of our consent forms mention this, but all consent forms are going to have a statement added to the confidentiality section indicating that de-identified information or specimens could be used for future undetermined research. Right now, the only thing we really have is that if you have identifiable information you want to use for future undetermined research, we have the optional section at the end of the consent form where they can indicate. So if you had video recordings and you were looking at mother-child interactions, and so you analyze it for this study, but this is so we want to use it for future studies, we get their permission to use it for future undetermined research because it's identifiable. Now what they're requiring us to do is, even if you collect data that is not identifiable, you need to put a statement in there saying, we're going to use your de-identified information for future undetermined research. Or you can say that even information, even those that are de-identified, so you have to tell them whether or not you're going to use it for future undetermined research. Is it a one and done for this study, or are we going to continue to analyze it? My guess is everybody's going to want to say, if it's de-identified, we're going to want to keep this stuff. It could be good down the road. So when it's applicable, you're going to have to talk about biospecimens being used, whether or not they could be used for commercial profit, and whether or not your subject will share in the profit. Whether or not clinically relevant results will be returned to them. So like in our consent forms that we have that involve MRIs, there is a section in there that talks about that when we have a radiologist look these over, if they see something that may follow up with their physician, that they would be given that information and a copy of their images to take to their physician. So you would have to tell your subjects whether or not that's going to happen. And when research will involve whole genome sequencing, you'll have to tell them that it's going to be whole genome. Some other notable things they've changed on us. If you are using secondary data that is identifiable and you want to request a waiver of consent, currently right now the criteria for a waiver of consent are that the study has to be minimal risk, you are not adversely affecting the rights or welfare of the subjects, that you would not be able to conduct your study without the waiver, and the last one is kind of an if applicable, that you would debrief them after the study. This one now adds a fifth requirement that says, if I'm getting identifiable information, secondary data, you have to justify the use of that identifiable information instead of getting it de-identified. So videotapes would be a perfect example. Unless you blur out their faces, you can't get it de-identified because you have that facial image. Clinical trials. The new regulations provide a definition of clinical trials. It's actually different than NIH's definition of clinical trials, but they're similar. So we read them as being the same. And we go with the more stringent one. One of the requirements now is that if you are doing an OHRP clinical trial, so the common rule clinical trial, you have to post your consent form to a public website by a certain period of time. So they haven't told us what website, and I think it's 60 days before enrolling your first one, or right after 60 days after approval. But we don't know where to tell people to post this thing because they haven't told us yet. So hopefully they'll tell us by July 19th. Broad consent. Broad consent for future research with identifiable data and specimens. Penn State is not implementing this provision by July 19th. So basically, as an alternative to kind of getting that optional permission, like for video recordings and things like that, they would sign this broad consent form that says, basically, you can do whatever you want with my data. That's not really consent because we're not telling them what we're using it for. So plus there's going to be issues with you as a researcher. If you would use broad consent, how are you tracking this information as to who says yes and who says no? And what if they come back and say, I don't want you to use my data for that anymore? You have to know that. Or if the same person participates in your study in different studies of yours, they say no for one study but yes for another study. And if they say no, can you go back and ask them again if they change their mind whether or not they would let you, keep this for future undetermined research? So we are not looking at implementing this by July 19th. We're kind of waiting for further guidance, and a lot of institutions are doing that because there's a lot of questions that were put in during the comment period before the regulations were accepted. And we still have a lot of questions for them about what all this means and how are we supposed to administratively keep track of all of this stuff. So elimination of continuing review. This is what y'all will be excited about. So anybody have expedited studies? So what this will do for you is you will no longer be required generally to do a continuing review. So that annual report that you do every year for studies that are eligible for expedited review, we would do away with that. For studies that are determined to be exempt, even if they have a limited IRB review, you wouldn't have to do a continuing review for that. For studies that have gotten to the point where the remaining research activities are limited to data analysis or accessing follow-up clinical care from standard procedures. So you still would be required, if your study is expedited, to submit modifications, to report new information. So if there's a problem with your subjects, if you go over your approved numbers, you use the wrong consent form, things like that would be reportable new information. You're still required to submit that, and you still be required to submit a study closure with us. What we are planning on doing is sending out an annual notice or check-in to remind you of these responsibilities and to check the status of the study. So we may ask you a question that says, are you still doing this research? Is it still active? If you say yes, we leave it open. If you say no, or we don't get a response, if you say no, we're going to say you got to go do a study closure. But if we don't hear anything from you, we will administratively close that study and you will no longer have approval. So it'll be important to reply to that check-in. So, single IRB review for cooperative research. As I mentioned, this goes into effect on January 20th, and so there's two different policies. So NIH implemented a policy that for any grant proposal that is being submitted to them from July 25th, 2018 after, if you're doing a multi-site research study, you have to submit to them along with your grant proposal a plan for having a single IRB review your study. So when we talk about a single IRB, we may have researchers from Penn State, Michigan, Maryland, and Rutgers doing a study. What these regulations are now telling us is instead of having 4 different IRBs at 4 different institutions review this, you need one. And so you have to, so cooperative research is different from a multi-site study in that cooperative research could be that each institution is doing a different piece of the research. So maybe we're doing the human subjects part and Michigan is getting identifiable data. So they're engaged in human subject research because they're getting video recording. So we would be their IRB of record, or they would be the IRBs. The institutions have to decide who's going to be the IRB. But we have to tell them, we have to figure out who that is, and then only that one IRB would be the IRB of record for all 4 of those sites. And that's for federally funded research. So it applies only to domestic sites, so only US sites. And there are limited exceptions. So I think Virginia and New York have laws that state that they can't enter into reliance agreements. So we would not be able to be a single IRB for those places, and they would not be able to be our IRB for any institutions in those states. If there are tribal law, so if we were doing research with Native Americans, if tribal law would prevent that and they say our Native American IRB has to review it and they won't be our IRB, then we would have, both sites would have to review it. So I would suggest for transitioning into this, our website up there has announcements from our office. So anytime we learn new things about the Common Rule, we will put information on that site. So July 19th and after, studies will, unless they push it back, new studies will be required to follow the new Common Rule unless it's FDA regulated or funded by the Department of Justice. So if you have an existing study, then you're going to be doing both with us. Your new study would use the new Common Rule regulations, and your old study would still apply to use the old regulations. Because we did not want to say, as of July 19th, all of our studies have to be brought up to the new regulations, because that's just, it's insane. Yes.
So are all the protocols and the templates?
The contemporary templates will change. We are working on that. We actually, even before these go into effect, we've been working on changes to the protocol. There's some sections where we consistently are not getting the information that we need. So we are trying to make that more clear. And we also, the look of it will be changing once those revisions are done, because we are going to fix it so that it's accessible. So individuals that need a screen reader would be able to complete that. Right now, it's difficult for them. So the whole look of it will change. So we are changing. Our investigator manual will change. Our SOPs will change. Templates, because our SOPs and checklists and worksheets that the IRB uses are in line with what the regulations are now. So we are working on that. We are meeting, since before the regulations were supposed to go into place in January. We've been meeting with IRB members, training with staff, changing these documents and working on them. But all of this stuff is going to change. So what you're going to want to make sure of is that you are using the most recent versions of our documents. So anytime you start a new study, please make sure you're coming into the templates tab and getting the most recent version of the protocol, the most recent version of the consent form, because they are going to be changing. We're going to try to release, especially the consent form template before July 19th. So if you're working on a study that you're going to submit after July 19th, you have that information. NIH changes. So these will be quick. As of October 2017, any studies that are NIH funded that we review, and this includes past ones from like December of 2016, they now all automatically have a certificate of confidentiality. Does anybody know what a certificate of confidentiality is? Okay, so certificate of confidentiality is an additional protection to you as a researcher. So if you were doing research on child abuse, this certificate of confidentiality would be able to help you from giving information over that is subpoenaed by a civil or criminal court of law. Previously, anybody, whether you're NIH funded or not, you had to apply, and sometimes the wait period could be long because it's through the federal government. But NIH studies now during the IRB review of their studies, we will process that for you. You don't have to submit separately. You will automatically have a certificate of confidentiality in your study when it's approved. We will have you put statements in your protocol that indicate that and what your requirements are for that certificate. We have standard wording for you to put in your consent forms. And then your approval letter will say that this study has a certificate of confidentiality. Anybody who is not NIH funded and you're doing sensitive research, you can apply separately for that, but that is an application that you have to submit separately. There are new, if you are submitting a grant proposal, there are new forms that have to be filled out if you're doing clinical trial stuff. So your grants and contracts office can help you with that, but if you don't submit the right form and you don't submit, especially clinical trial, to the right place, they will reject it. So they also recently revised, or they're going to revise, requirements for the inclusion of women and minorities in research, and their requirements for the inclusion of children in research. Clinical trials. They have changed their definition of a clinical trial and is now more broad. So some researchers who never would have done a clinical trial before, their study now falls under the definition of a clinical trial. So there are additional things that have to be done. They would have to take, if it's NIH funded, they have to take GCP training, good clinical practice training. And they have to register their study at clinicaltrials.gov. What else? Oh, so this took effect January 25th. I just mentioned this, that if your proposals have clinical trials, you have to submit them through a funding opportunity announcement, I think it's called, that is specifically designed for a clinical trial. So if your study is a clinical trial and you don't submit it to one of the FOAs that is specifically for clinical trials, they will reject it. You have the new Form Z, and there are new review criteria that is specific to clinical trials. And so, again, this is NIH, NIH money. NIH also has a new requirement. See, we didn't only just get the common rule stuff. NIH has been out there fair share of changes too. So this also went into effect on January 25th. Multi-site research. So you're doing the same exact protocol could be carried out at one or more sites. So not that I'm collecting all the data and Michigan's analyzing it. Michigan and Penn State are doing the exact same study. There's a PI at Michigan, there's a PI at Penn State. But on the grant proposal, Penn State gets all the money and then we give it to Michigan. So we're considered the prime awardee. But when they submit that grant proposal, they have to have a plan in place on who's going to be the IRB. That does not mean that if you think Michigan's going to be the IRB of record, that you don't have to talk to us at all. The researchers don't determine who's going to be the single IRB for NIH-funded research. The IRBs determine it because we have to look at expertise on the board, whether or not we can handle something like that. So if we're getting a study that has 20 different sites, we aren't going to be able to handle that. We may have to look at other options. Can another IRB out of those 20 sites be an they need to contact us as soon as they possibly can, because it can't be something that waits until the day before the grant proposal is due, because we have to get the agreement of all of the sites on who's going to be the IRB of record. Available resources. If anybody is, so our office handles all of the colleges and campuses except the College of Medicine. So we're University Park and all the other 23 campus locations. And then that's the Office for Research Protections. College of Medicine and the Hershey Medical Center have a separate IRB and the Human Subject Protection Office. So if anybody's doing anything with College of Medicine or your regional campuses, you want to contact them. Anybody else? Contact us. Anybody have any questions? Like 101, but.